I'm not picking and choosing how things apply. I base it on their own words, like in this case from 2022. This is called Barron versus City of Baltimore. You can go read it. It's 32 U.S. 243. I'm going to just pick out some certain things because it's too much to read in a 3-minute video. The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. Each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the powers of its particular government as its judgment dictated. Okay, you go down here. The Fifth Amendment of the United States Constitution applies only to the federal government and not to that of the states. The provisions in the Fifth Amendment of the Constitution of the United States declaring that private property shall not be taken for public use without just compensation are intended solely as a limitation on the exercise of power by the government of the United States and are not applicable to the legislation of the states. Because, see, what you're concentrating on is a federal constitution. No one looks up their own constitution. And there are two citizenships. I'll go over those cases here in a moment. But you do have it clearly laid out in the courts that there is a federal citizen under the 14th Amendment, and there are the citizens of the states, because each state is a sovereign country in and of itself and is a foreign jurisdiction to each other, and they created a foreign jurisdiction called the United States, otherwise called the federal government. See, they did the same thing with the European Union. We were the first derivative of that, if you think about it. Now, let's look at the three United States. This case right here, Hooven and Allison Co. versus Avat, Tax Commissioner of Ohio. Look at here. The term United States may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in family of nations. It may designate territory over which sovereignty of the United States extends, or it may be collective name of the states which are united by and under the Constitution. So right there they tell you there's three United States. And in the case, that's what they say. Okay? While belonging to the United States as a sovereign or not part of it. Okay? Right here, the term United States. When Brown v. Maryland was decided, the United States was without dependencies or territories outside its then territorial boundaries on the North American continent, and the court had before it only the question whether foreign articles brought into the state of Maryland could be subjected to state taxation. See, we're not reading these court cases, but right here's the very part I read. The term United States may be used as one of several senses. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. Okay, that's the federal government. It is international law, and it contracts with other nations. You can see that in 28 U.S.C. 3002 paragraph 15a, that it has the right to contract because the government created a corporation, and I'll show you that in a moment. It may designate the territory over which the sovereignty of the United States extends. Okay, now that's Article 1, Section 8, Clause 17, otherwise known as territorial jurisdiction, which is D.C., its insular possessions and territories. Or it may be. That or is very powerful. That means that's a distinction, a separation. Or it may be the collective name of the states which are united by and under the Constitution. So when you say you're a U.S. citizen, which citizen are you? So I'm not making anything up. Look at this. Let's go all the way down to United States. United States. Oh, what does that Part 6 say? Corporations, special instrumentalities, and similar entities controlled by the United States. Corporations? Really? You mean the United States can control or own corporations? Oh, yes, they can. Look at this. Corporation is part of government for constitutional purposes when one, government creates corporation by special law. Oh, they did that in 1871 with the District of Columbia Organic Act. Government creates corporation by special law. Okay. 2, for furtherance of governmental objectives. And 3, retains for itself permanent authority to appoint majority of directors of that corporation. They say this head note over and over. That's a 2023 case. But look, they say the same thing in 2021. Let's see, 2020. Again in 2020. These are all court cases. Let's go to the end of the list. Corporations created by the authority of the United States are not foreign corporations, but have legal existence in every state in which they may transact business pursuant to the authority conferred on them by Congress. A corporation, which is an agency of the government, is not the government or a department or officer of it. Congress may create a corporation as a governmental agency to fulfill governmental purposes and endow it with powers of a private corporation. See, again, which citizen are you? Now, let's go back to 1873, which is only 2 years after the D.C. Organic Act and only 8 years, no, 5 years after the 14th Amendment. Okay, what do they say here? This is the case of Susan B. Anthony when she went to jail for voting in a federal election. Now, why did she go to jail? Because she was not a U.S. citizen. And they explain that here. They also tell you people think they know what their rights are, that they have a right to vote in a federal election. No, you don't. The right or privilege of voting, oh, they call it a privilege, is one arising under the Constitution of the state and not under the Constitution of the United States. Oh, well, isn't that interesting? And go down here. The 14th Amendment protects only such rights as are rights belonging to a person as a citizen of the United States and not rights belonging to a person as a citizen of a state. Wait a minute. There's a citizen of a state and a citizen of the United States? And the restriction under the Constitution and laws of that state of the right to vote to males is not a violation of such amendment, which provides that no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, as the right or privilege of voting is one arising under the Constitution of the state and not under the Constitution of the United States. Oh, go figure. And if you scroll down and read it, the 13th, 14th, and 15th Amendments were designed mainly to protect, for the protection of the newly emancipated, I'll say the word slaves, but full effect must nevertheless be given to the language employed. The 13th Amendment provides that neither slavery nor involuntary servitude except as a punishment for a crime, blah, blah, blah. The United States or any place subject to their jurisdiction, if honestly received and fairly applied, this provision would have been enough to guard the rights of the colored race. In some states, it was attempted to be evaded by enactments cruel and oppressive in their nature. And if you continue to read, the 14th Amendment creates and defines citizenship of the United States. It has long been contended and had been held by many learned authorities and had never been judicially decided to the contrary, that there was no such thing as a citizen of the United States except as that condition arose from citizenship of some state. That's because why? The 50 states united. No mode existed, it was said, of obtaining a citizenship of the United States except by first becoming a citizen of some state. This question is now at rest. The 14th Amendment defines and declares who shall be a citizen of the United States, to wit, all persons born or naturalized in the United States. Now, if you want to know what in the United States means, you need to go read Article 1, Section 8, Clause 17. It's DC, its 10 mile squares, and its insular possessions. It's not necessarily the 50 states. Now, this stuff I'm reading is just excerpts from this case. Okay? Has this changed? Well, it says, after creating and defining citizenship of the United States, the 14th Amendment provides that no state shall make or enforce any law, blah, blah, blah. This clause intended to be a protection, not to all our rights, but to our rights as citizens of the United States only. That is, to rights existing and belonging to that condition or capacity. The expression citizen of a state, used in previous paragraph, is clearly omitted here in Article 4, Section 2, Subdivision 1 of the Constitution of the United States. It had already been provided that citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. Now, let's look and see if that's changed in all these years. Now, has the thing of two different distinct citizenships changed? The answer is no. That case that I just showed was 1873. This is actually, wrong one, Jones v. Timmer. I need to learn to spell. Now, this was, what, 120 years later, 1873 to 1993? What does it say? Privileges and Immunities Clause of the 14th Amendment protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. Go figure. Now, go down here to number 13. Let's see. Nope. Well, we'll scroll down because it goes over in two spots. So, if you look, there's 5, there's 6, 7, 9, 10. The Privileges and Immunities Clause of the 14th Amendment protects very few rights because it neither incorporates any of the Bill of Rights nor protects all rights of individual citizens. See the slaughterhouse cases, which was decided before U.S. versus Anthony 5 years after the 14th Amendment. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which are related to state citizenship. Now, they thought this was so important, they didn't just say this one time in the case. They said it twice. The Privileges and Immunities Clause of the 14th Amendment protects very few rights. To my knowledge, in the history of the United States Supreme Court, only one decision determined that a state violated this provision, And that decision was overruled within a few years. That was Colgate versus Harvey, overruled in Madden versus Commonwealth of Kentucky. The Supreme Court held that this clause neither incorporates the Bill of Rights nor protects all rights of individual citizens. Rather, the provision protects only those rights peculiar to being a citizen of the United States. It does not protect those rights which relate to state citizenship. They thought it was so important they said it twice. Huh, go figure. So I do not pick and choose what I believe and what I say. I read it from their own words, sir. So you can say I pick and choose all I want, but this is their rules, their laws.